Good evening, everyone. This is Councilor Katie Roby. I'm the chair of the Urban Affairs Committee, and we are going to begin with our meeting this evening. It is Tuesday, May 11th at 7 o'clock. We have technically two items on our agenda. Before we start, because some of us are on Teams and some are in the chambers, I'm going to do a quick roll call. Councilor Landers. Councilor Doucette.
Councilor Doucette is present.
Councilor Navin.
Councilor Navin is present.
Councilor Wagner.
Councilor Wagner is present.
And Councilor Roby is present. I believe we also have in the room, in the chamber, Councilor Ossing and Councilor Dumas, and on the teams, Councilor Perlman. So our first item on the agenda is 21-100-8214, which is an application for a special permit from Calverde Naturals LLC to operate an adult use marijuana retail establishment, 239 Boston Post Road West. I believe we have Randy Myron and Mark Donahue with us. I don't know if we have any of the Tomasellos or not, or if it will be you two representing. I don't know if either of you have anything you want to say before we begin going through the draft decision.
If I might, Madam Chair, Mark Donahue on behalf of the applicant. I do believe Mr. and Mrs. Tomasello might be present also. Mr. Myron is, as is Mr. Allen, the Director of Security. We made a presentation to the City Council on March 22nd, so in the interest of brevity, we won't repeat that, but we're glad to answer any particular questions that any of the councilors may have with regard to the application or the proposed decision.
All right, so the council members, the committee members, and the rest of the council received your draft decision. And I believe we have Attorney Grossfield with us also, so he can help us as we go through this if there are any questions, or we'll keep track of any potential changes that may be made. I understand, before we get into this, you have received a provisional license from the CCC.
That's accurate, Madam Chair.
Okay, so let's begin with the draft decision. As was indicated in the information that the solicitor gave to us when we had our little learn about special permits, we begin with the findings of fact, which I think are pretty much typically ignored by the City Council, and we get right to the conditions. But I do want to go through them quickly just to make sure. There are a couple of things that I know need to be talked about. We begin with the basics, where the applicant is the prospective tenant of a space at 239 Boston Post Road West. They seek an adult use marijuana retail establishment. The site is in the business zoning district with frontage on Boston Post Road West, and it entails construction of a standalone building dedicated to the use to be constructed by the applicant with an existing development pad at the site. So we get to number 8 in the findings of facts, and it talks about the applicant submitted a certified list of abutters, filing fees, existing site plans for the site in accordance with Rule 5, and it goes on from there. In looking at this, it is actually Rule 4, but in talking to the solicitor, I think we can probably make an amendment. And I know I had some verbiage, which I seem to have lost my note. But I think in talking to Priscilla Ryder from Site Plan and looking at other site special permits that we have, we think it's important to point out the actual site plan information. So I can leave it up to the solicitor to come up with the language, but I think if we delete the Rule 4 part and just say that it's in accordance with the rules and regulations, that should be sufficient. And then he can work with the fact that we received from you both a set of plans and a set of photographs and the concept design, which has the floor plan. So I think if those are specified in here, in number 8, it's probably a good idea. And solicitor, if you're there, if you can confirm that, I'd appreciate it.
Yes, Madam Chair, I think you summed it up perfectly, and those are the exact kind of changes that we'll incorporate into that paragraph.
Okay, so that everybody's aware when we get this in final form from the solicitor, that will be a change. And then in number 9, again, it says the application was certified by the building commissioner, and it talks about Rule 4, items A through M. This is actually Rule 7, and again, I think it's probably easier to just delete that whole rule, items A through M, and have it just say as having complied with the rules and regulations promulgated by the City Council. That way, if the rules get added to or changed, we're not looking for a certain number, we can just go back and look. Does that sound okay with the applicant for both of those changes?
Absolutely.
All right.
Yes, Madam Chair.
And then from there, it just goes on and talks about the public hearing that was held. It was on Monday, March 22nd. The applicant presented testimony and demonstrated that the proposed use is not located within 500 feet of an existing public or private school. And at the public hearing, there were no members of the public that spoke either in support of or in opposition to the use. So is there anybody on the committee who has any questions or concerns with anything we've gone through that I went through quickly there? No. If not, we can go to the next section, which is the specificity, where we are getting to a lot of the information that is really in the Cannabis Control Commission's bailiwick, that they're required to make sure that they meet everything. It talks about the social, economic, and community needs. This does reference that there is an annual community impact payment that Cal Verde will be making to the city. Talks about the traffic flow and safety and adequacy of utilities and public services, the neighborhood character and social structure, the impact on the natural environment, potential fiscal impact. And again, they're specifying that this will be revenue positive with additional revenues from the local sales tax and a host community agreement impact fee. The hours of operation are specified in the conditions. They will be providing us their contact information with their employees. They're going to have to pay a community impact fee that was already talked about, and requiring that the submission to the special permit granting authority of annual reports that are provided to the Commonwealth of Massachusetts and the CCC will also be submitted to us. They will allow regular inspections. Their employees will undergo query checks and anything else the chief of police wants them to undergo. They will have 24-hour video recording, and that is in a condition. They're prohibited from selling anything except what is regulated for them to sell, and the ability for the business to have a whole list of things that are in the conditions, so we'll go through those. Signage will be shown on plans, and the name of the business and the business logos are subject to state and federal laws and regulations. So we get on page 6 of the application to the specific conditions that are listed. Number 1 is construction in accordance with applicable laws. It's pretty common. Number 2 is compliance with applicable laws. Number 3 talks about site plan review. Number 4 is the incorporation of submissions. So everything that you have submitted to us is part of this special permit. We have number 5 is compliance with the state requirements. So in accordance with 650-1846C, you have security as shown on the plans. Maintain a secure entry and exit vestibule, providing a physical separation between the exterior door and the interior areas. You will have opaque exterior windows. You'll maintain adequate staffing so customers can make purchases in an efficient manner. And you will maintain surveillance cameras capable of 24-hour video recording. Number 7 is the processing and odors, which really just states that there's no...
Madam Chair, it's Councilor Doucette.
I'm sorry, Councilor Doucette.
Yes, thank you very much. I still have some questions that we're going through number 6. I wasn't sure where else to hit it, so I'll bring it up there. First, I just want to make a comment in reviewing the material that Cal Verde has presented to the city. I am impressed in the quality and the caliber of everything that you guys have provided. It's, you know, you guys have really put together a nice package here, and I truly appreciate the information you provided. There is a couple of things based upon going through the other materials. First is police detail. That is not part of the conditions yet, and I assume that would be under security, because if it's not there, it would probably be someplace else.
Councilor Doucette, it is actually something that has always been almost very last on all of the other plans. It is in my notes to make sure that we add that information so we can...
Okay. The other question I had, because they were planning to do a soft opening, and I think the idea of a soft opening makes a lot of sense. My question is, how much of a police detail is there during the soft opening versus the full opening? The whole idea of the soft opening is that you don't have the volume that maybe a police detail is needed. So that was kind of the conversation I was planning to have as well. We can cover both of those at the same time. The other thing, as far as the camera, they have a camera to basically show your ID. And this is just feedback to them. It's not part of the conditions, but you know, the consumers of cannabis of all ages, including those who are not necessarily technically literate. So you may want to have a screen out at the camera so that people see what's actually being displayed back to who's on the other side of the camera, because they might have trouble basically holding the ID at the right level. Also, as far as identification goes, what about passports? I mean, there's a lot of people that don't have driver's license that have passports. Is that going to be accepted?
Mr. Donahue, do you want to answer that question? I'm sure that the CCC regulates what's a acceptable license identification.
Through you, Madam Chair.
Kelly.
I'll defer either to Mr. Allen or Ms. Tomasello to explain specifically the questions with regard to security.
Sure, this is definitely a question for Chief Allen to answer.
Good evening, everybody. Mike Allen, Chief of Security for Cal Verde Naturals. To answer the question of passports, absolutely, they are an acceptable form of identification that we can accept, and we will have an ID, an electronic identification scanner that will scan passports to ensure that the passport is a legitimate passport and hasn't been altered in any way.
Okay, thank you very much. I appreciate the clarification.
Sure.
And we're going to put the police detail towards the end. Is that your intent, Madam Chair?
Yes, in prior ones it was after number 14, so I do have it marked. And
okay, I'll leave my comments until that point. Thank you. I appreciate it.
All right, I was going rather fast. Did anybody else have questions on the security part or anything else that I've gone over so far? I don't see any hands. I can't really see the room that well. So if you're in the chambers, please speak up. Right, we are on number 7, the processing and odors. So they cannot process or manufacture the marijuana. They're actually going to be bringing it on site. Their hours, they are asking for the hours to be Monday through Saturday, 10 a.m. to 8 p.m. and Sunday from 10 a.m. to 5 p.m. I will throw this out to you. We did amend a special permit already for additional hours. If you think you might want additional hours, this is probably the time to raise your hand and say we want to change these now, and we can talk about it. Otherwise, you need to come back and amend.
If we might, Madam Chair, certainly the more hours, the merrier as far as the permit's concerned. So if the council is open to either an opening early or remaining open, whether that will fit the demand of customers or not will be proven out through the operation, but we'd certainly like the flexibility.
All right, I will tell you, we amended Garden Remedies, which was our first applicant for a special permit. Their hours are 9 a.m. to 10 p.m. Monday through Saturday, and 10 a.m. to 8 p.m. on Sunday. So they opened a little bit earlier, stayed open later during the week, and then later on Sunday.
If we have the flexibility to operate within those hours, we greatly appreciate it.
And council members, does anybody have an issue with amending the draft to match the hours that we gave to Garden Remedies? 9 a.m. to 10 p.m. Monday through Saturday, 10 a.m. to 8 p.m. on Sunday. Councilor Landers.
I'm all for, what if you have all...
Microphone, Mike.
You know, let all the shops, you know, have their own, the same hours. If they don't want to be open, fine. But I think we might as well settle it right from the get-go and give them that range if they want to open or wait and see how their business does. I mean, I think Garden Remedies, they set the tone. So why shouldn't the others be similar?
I would agree, Councilor Landers. I know we gave this an option to the most recent special permit, and they didn't want to increase their hours. So I thought I would throw it out there. Anybody else on the committee with comments on amending the hours?
I'm fine with amending them to match Garden Remedies.
Anybody else that's here this evening with?
Councilor Robles, Councilor Ossing.
Councilor Ossing.
Thank you, Madam Chair. I have no issues with extending the hours. It lines up with Garden Remedies. Thank you.
All right, so we will amend those to be what I described. All right, we're at number 9, which is the contact information, which just says that they will provide to the Chief of Police, the Building Commissioner, and the City Council. Number 10 are the annual reports that they have to submit to the City Council. Number 11 is inspection and records. They'll make the use available for regular inspections by the City Council. Number 12 is background checks. Again, this is Corey checks that the Chief of Police will require. Number 13 is unrelated material. This is the part that says they will not make available for sale anything unrelated to the purposes of registration by the Commonwealth of Massachusetts. So this is where we would add in the police detail. So in the other applications, which you might have read, I don't know what you got for using your draft. We do have the applicant, its successors and/or signs shall employ a City of Marlborough police detail at the site during all operating hours for the first 60 days after the commencement of operations, unless the Chief of Police determines in a letter filed with the City Council that a police detail is not necessary during certain times of the day. At the end of the 60-day period, if the Chief of Police determines in a letter filed with the City Council that a police detail is still necessary during all operating hours or at certain times, then the applicant, its successors and/or assigns shall continue to employ a City of Marlborough police detail until deemed unnecessary by the Chief of Police in a letter filed with the City Council. In the event a City of Marlborough police detail is not available, when required, the applicant, its successors and/or assigns shall obtain a private detail. So it's basically 60 days. Within that 60 days, if the chief says we're not needed, he writes a letter. If at the end of 60 days he says I'm still needed, he lets us know, and there's an extension.
Madam Chair, it's Councilor Doucette.
Councilor Doucette.
Thank you very much, Madam Chair. The other thing, as far as the documentation that Cal Verde provided to us, the important difference is that it's the police chief who decides, not the business, whether or not the detail is needed or not. So I just wanted to emphasize that point because they were referring it, saying it was the business's choice, and it's not in this case. So just to make that clear. Also, I actually have another condition to add if we're done with the police detail.
Is everybody okay with making the addition into this, what I just read, the number 14 from BD Natural special permit is basically what I read. If the solicitor wants to use that as the language that he will add in. And is that all right with the applicant? Or even if it's not all right, if we're adding it, it's pretty much a standard condition. I know we've only had one opening so far of all of the special permits that we have given. It was not an issue at all with the very first one, Garden Remedies. They didn't require additional, and I think from the sense of the chief of police, it's probably wouldn't even last 60 days for other ones. It seems to be not an issue for lots of traffic congestion. You have a pretty good site for in and out and parking. So.
If I might, Madam Chair, we certainly don't have an objection. We did not include in the draft with the thought that given the fact that we're building new and therefore still have a significant amount of time before opening, the competing pressures will somewhat ameliorate the concern. But if the council is more comfortable in requiring, we don't have any objection to a condition of working with the chief of police toward that end.
Thank you. Yeah, I realize that it will be a while before you are open, but I think the issue is still the establishment. You are in a relatively busy place, so it.
Not an issue for the applicant at all.
All right. So, Councilor Doucette, you had another condition you wanted to add?
Yes, thank you very, very much, Madam Chair. So, just as a background, there are 4 licenses for dispensaries within Marlborough. This is the last one, and this has been somewhat of a learning in new territory space for the council as well as for the city. The first one went without a hitch. The second one that we approved with doesn't seem to be going anywhere. The third one is under construction, and now we're on to the fourth one, which is going to be a new building. And my concern is basically that this gets completed and the license is available to serve the community. And I think it's important that we basically put a time constraint that can be extended, but just basically, you know, if, let's say, in the last conversation we had during the public meeting, I think you were trying to get opened within 18 months. Correct me if I'm wrong. But I'd like to see something like within 2 years, the business, if it's going to take more than 2 years for this business to open, you can come and ask for an extension. My concern basically is if it falls apart in 2 years, then you forfeit the license.
So, Councilor Doucette, we do have Solicitor Grossfield with us on here. He can give us specificity on how long a special permit lasts if no building permit is actually applied for. Does the special permit die?
Madam Chair, it does lapse at some point if substantial use is not reached. And I believe the ordinance is 3 years, but they can be conditioned to be less than that. And I think that that's something that the committee can discuss with the applicant, certainly.
And just to be clear with you guys, you know, at Cal Verde, you know, I wish you guys the best in opening your business. It's just, we've already seen one fail to the side, and I just want to make sure that we don't lose another license.
Through you, Madam Chair.
Yes, I'm sorry. Who was speaking? Mr. Donahue, or?
It is, with
Yeah.
your permission.
Yes.
Thank you. Certainly a condition that requires commencement of construction of the structure within 2 years wouldn't be problematic. We do have local permitting still to do, and we do have state permitting that needs to be completed. So I wouldn't want to have a condition that said we had to be operational, since we don't control some of those timelines. But a condition that required commencement of construction of the building reflected on the special permit plans within 2 years would be a reasonable condition we could live with.
What about if the condition was for 3 years to be in operation then? I mean, I want to put the condition on operation and not just the building being built, you know?
I don't think that's problematic. We could certainly come back, certainly within the 3 years,
Right.
if we ran into some surprising hiccup that I can't foresee right now. But 3 years is
Understandable.
a long time.
Right, yeah.
And Mark, we don't have an issue with those conditions.
Right.
Okay, thank you.
All right, so Counselor Doucette, are you okay with the solicitor writing that language, or do you have something specific?
I will reach out to Solicitor Grossfield on the proper legal term, and Counselor Landers was raising his hand.
Madam Chair, I just have...
Is your mic on, Don?
Yes. Madam Chair, I just have a couple questions for them. Now, I think the landlord is building this building, and you're a tenant, is that correct? Are you
Ms. Tomasello?
building the building, or is Arcade Plaza building the building? But where I'm going with this, I assume that at some point you're gonna sign a lease with them.
Counselor Landers, they're trying to answer your question.
Okay.
Through you, Madam Chair, we do have a lease in effect now. It is a ground lease, and therefore Calverde will be constructing the building. And it obviously has conditions for the payment of rent to RK and the like. But the capital cost is borne of building the building is borne by Calverde.
Okay.
And a requirement that we be in operation within 3 years of the approval of your special permit and the expiration of the appeal period is fine with the applicant.
So your lease is on the parcel of land?
That's correct.
To Arcade Plaza, okay. And you people are building the building?
That's accurate, Counselor.
The reason I only bring that up, it seems to me, 3 years is a long time. If you're gonna make money in this business, there's getting to be so many of them, there's gonna be 4 in Marlborough probably by the time you open up, that I would think people would move faster. I mean, we build schools in 18 months and churches in 2 years and stuff like that. It seems to me that the sooner you build it, that's what generates the revenue, and that's how you pay your cost, But I agree with some of my colleagues here. I hate a building just sitting there. I'd like to see you open in 18 months, to be honest with you.
Through you, Madam Chair, I would share the council's desire to be open in 18 months. I think the question is the measuring period, because there are other permits required and approvals required in order to start the investment of the capital. So I think it's either when you start construction, which is a shorter period of time, or when you open, which is the longer period of time. And I think while 2 years seems like a long time, it goes by in a nanosecond when you still need approvals from both the city and the state before you can start the work on it. So we're happy with either starting an obligation to start construction within 2 years, or be open within 3 years. And I share the council's desire that all of this becomes immaterial, that we're actually open within 18 months.
And Mr. Donahue, I know that you are opening a facility in Belmont, not you, but Calverde is. Can you kind of do a timeline of that process? Was it a building, brand new building?
Sure, Kelly?
It's Steve Tomasello here. Hello, everyone. Thanks again for the time. Currently in Belmont, they're mirrored paths. We're presenting in front of the planning board in Belmont on May 18th. That is an existing building that'll be renovated. So most likely, if things go smoothly through the permitting process, the local permitting process there, we're hoping to be under construction by the end of the year and renovating the building for spring opening of 22.
Okay, it looks exactly like our picture, so I thought maybe it was a brand new build, but.
Very similar. We're trying to keep the brand the same.
All right, so we will leave it then, I guess. Councilor Doucette, do you want to determine which one you want to go with now so that when we're voting, we know which condition is going to be added?
I think it's open, business open, begin of operations. Because I think that's the important part.
Within 3 years.
Within 3 years, yep.
All right, so the solicitor will come up with the language, but basically nobody else on the committee has an issue with the additional condition that they must be open within 3 years from the date of the approval of the special permit. Would that be the starting date?
Yes.
Anybody else with comments on that? All right, I'm not seeing any. So we will look for the specific language from the solicitor. The very last condition is the typical one, number 14, the recording of the decision. This will be changed to 15, I guess, if we're going to add in 14. It's just language that's in all of our special permits. So with that, is there any further comments? We need a motion to approve as amended from someone.
Motion to approve as amended. Councilor Doucette.
I'm sorry.
It was Councilor Doucette. Motion to approve as amended.
Was I going to say, do we want this to come back to the committee to look at the language, or are we okay with, I can ask for a suspension, when are we meeting, on the 26th, to have it sent to the solicitor to be put in proper form?
So question to Cal Verde, what's your urgency for this? How quickly do you need this special permit?
Through you, Madam Chair, it's part of the process. Obviously, we need to have the special permit to go and obtain site plan approval. So I certainly won't suggest that we need every single week, but time is obviously important in any kind of development. And the sooner we can get to market, the sooner we can respond to council's concerns about opening. So it's really up to the matter of the council's convenience and scheduling.
So the options are have it go in legal form back to the council, or have it go in legal form to the committee? Is that the two options, Madam Chair?
That's correct. We can have another meeting where we can have this in the new condition and the police detail added. We can look it over, confirm it's what we want, and then it can be reported out at another meeting, which probably would not be before April 26th. So it would just add a delay, but.
I think it's May 24th.
I assume, but without speaking for the solicitor, that the language to be added with regard to the requirement to be open is relatively straightforward. We have confidence that the solicitor's language will be acceptable, and so we'd ask for suspension, but it's not a hill that Cal Verde's going to die on. It's up to the council.
Madam Chair, Councilor Navin.
Councilor Navin.
Thank you, Madam Chair. I don't think it's necessary to have another meeting just to go over this language. I think it is pretty straightforward, and I think the solicitor has a pretty good idea from the comments that have been made about the intent of the committee, so I'd be fine with that suspension and it going to the council. Thank you, Madam Chair.
All right, so is that okay with you, Councilor Doucette? You've made the motion to approve as amended.
Motion to approve as amended, absolutely.
All right. So we will do a roll call on that motion to approve as amended. Counselor Navin.
Counselor Navin votes yes.
Counselor Wagner.
Counselor Wagner votes yes.
Counselor Landers.
Counselor Landers votes yes.
Counselor Roby votes yes. And Counselor Doucette.
Counselor Doucette votes yes.
All right, so I will report this out on the 26th of April, ask for a suspension so it can get referred to the
Madam Chair,
solicitor
you're
to
in
be
the
put in
wrong month
proper
and the wrong
form.
day.
We would then vote on May 10th.
Sorry, you're back a month. It's May to June, right?
May and the 24th. Is it?
We're in May, not April. Madam Chair.
Oh my goodness, okay, calendars. All right, so let's see, today's May 11th. So I would report this out on May 24th and vote on June 7th. Thank you.
No worries.
All right. So we are finished with that piece of this, unless anybody that's on for this part has anything else they want to say. You don't really have to come to the council meeting on the 24th if you don't want to. It'll just be reported out, referred, and then on June 7th, when we do the final vote.
Thank you, Madam Chair, and all the members of the council for your consideration. Greatly appreciated.
All right, thank you. We look forward to hopefully getting this approved and seeing some construction.
Thank you.
Thank you, everyone, for your time. We appreciate it.
Good night, everybody.
Good night.
Good night.
All right, I just threw away my agenda. All right, so we have with us for item number 2, which is order number 21-100-8216, a proposed zoning map amendment to Results Way Mixed Use Overlay District and proposed revisions to Chapter 650, Section 33 of the Zoning Code. So I believe for this we have with us Attorney Tam, we have Daniel Keys, David Gillespie. Is there anyone that I am not seeing that is here for this meeting?
Thank you, Madam Chair. Peter Tam for the petitioner. I believe also on this virtual meeting is Phil Dorman, managing partner at Greatland Realty. And you've got Dave Gillespie from Avalon Bay Communities, and I believe you identified Dan Keshes as well from VHB, the project engineer.
Yes, okay. So I believe you have a little presentation that you would like to give before we get into the proposed amendments.
We do, and if the clerk wouldn't mind driving the show. We'll be very brief, but we think it is worth, without rehashing all the items that you heard at the public hearing, we thought it would benefit the committee and those counselors in attendance to just touch on where we're at and where we'd like to go with this. I will spend a little bit of time talking about where we're at. I'm going to turn it over to Phil to talk a little bit about the purpose behind this and Greatland's vision, and then we can get into the technical details. But first and foremost, we're here to address and listen to your concerns and comments and address them to the extent we can. So next slide, please. This is sort of a quick outline of, and I think we can do this in 15 minutes or less. That's my goal. I'll touch on the purpose, the process, where we're at. We'll talk a little bit about the site conditions, which are relevant to the rezoning and the map change. And I'm going to turn it over to Phil to talk a little bit about the master plan, which has relevance because of the process involved here. And then we'll get into the technical items that I think may be of particular interest for the committee and counselors that are in attendance. Next slide, please. So the petition here is an affiliate of Greatland Realty Partners. The owner is affiliated with Greatland, who purchased the property relatively recently. The subject property is the campus at Marlborough. It's about 120 acres that comprises 2 parcels, well, technically 3, and we can talk about that. And we're before you, as the chair indicated, both for a zoning text amendment as well as a map amendment. And this is all to affect a new master plan that Greatland is proposing. Next slide. So it's important for the committee to understand this is only the first step in a 4-step process. If the zoning is adopted by the council ultimately with the support of the committee, we would then be submitting a master plan to the city council. That master plan, much like the master plan that was adopted next door, would comprise the boundaries and concept, sort of proof of concept. It would have the building envelopes, the driveways, the access, the open space reflected on it. With that master plan, there would be a development agreement that the city council would also review and ultimately need to authorize. And that really outlines the implementation of the master plan. Following that process, that development agreement also would define any mitigation associated with the project and the master plan, as well as any limits on development. And then lastly, the site plan review and approval process would also be a city council action. They would approve it, the council would approve it with the recommendation of the site plan review committee. And that is where each specific individual project would be advanced, and technical information, including utilities, drainage, and traffic, would be assessed. So the bottom line is we're here before you in the first step of what is going to be a lengthy process with a number of opportunities for the council to be involved, to review, and to ultimately authorize specific projects that are consistent with the master plan that you'll see outlined this evening. Next slide, please. So this is where we're at in the process. We were before the council back in March. We've reviewed and gotten some good feedback from the planning board in order to get their recommendation. So we're before the committee this evening with hopes that we'll be before the city council soon enough. Next slide. Again, the subject site is approximately 120 acres. There are 2 parcels, if you're not familiar with them. The principal parcel on which the office complex is developed is the lower parcel that you see here shaded in blue in the yellow circle. The northerly smaller parcel on the other side of Martin Angelo is undeveloped and has not been subject to prior permits and approvals. You see to the top right, the Results Way Mixed Use Overlay District. The existing Results Way Mixed Use Overlay District is just across Cimarano Drive. The site is currently zoned industrial, and that's important as we get into the details. Next slide, please. So I'm going to turn it over to Phil Dorman from Greatland just to touch on existing conditions and preview the master plan with you. Phil, if you're available.
Yep. Thank you, Peter, and thank you to the committee and Madam Chairwoman for the opportunity to speak. We were thrilled to invest in Marlborough in this property last summer. The biggest challenge we saw was the persistent vacancy that had been at the property for quite a period of time. It was north of 25% that had really languished, but we felt that the quality of the buildings, the existing customer base, the location, and of course the municipality that it was in was a great opportunity. And my understanding is that you folks are intimately familiar with the property, so I'm not going to spend a lot of time rehashing that. But I think we are very happy to be reporting, and I believe the vast majority of the people on this call are aware that we are in the final stages of relocating BJ's Wholesale Club's headquarters from Westboro into the property, absorbing all of the vacant space as well as a significant amount of future lease expiration under a commitment that will be about 190,000 square feet over 20 years at the property. So we're thrilled to be bringing new commercial occupancy, new jobs into the property in such a short tenure, really, 9 to 10 months after we purchased it. And I think it's a testament to the quality of the property, as well as our ability to attract high quality companies to the area. But as we look at it, while we're thrilled that we have effectively fully stabilized the existing buildings, they will be essentially 100% leased for quite some time once BJ's moves in. In our minds, we're sort of only half done here because, as you know, there's over 100 acres of additional land here with a second phase that was always envisioned at the property that was planned for office and has not been economically viable for many, many years. And notwithstanding the fact that we were able to attract a large office tenant to the property, the office market still remains at a point where the market rent does not justify new construction. So I think we look at the unrealized potential of this additional land and the original master plan as something that, as we sit here today, is still probably not viable in terms of the market for office space and what is planned. And so as we look to the future, we think about what we could create here. We start to focus in on a mixed-use vision. So if someone could advance the slide, that would be helpful. To the next slide. What we're focused in on, if I could get that slide advanced, that would be great. Yes, there it is. Is a mixed-use master plan that looks to leverage the existing office space that we have, the great customers that are there, and the great infrastructure that we have, and apply the development rights in a way that is more likely and more responsive to the demand that does exist in the market that could support new construction. And we've effectively broken it into three major moves. The first is enhancing our existing amenities program in the middle of the project to be a more robust central square of retail style amenities that portions of them will be open to the public: dining, cafe, other outdoor recreation, those types of things that create a more dynamic work environment in the middle of the project, ringing the outside of the project with life science-based facilities that are primarily focused on manufacturing, clean manufacturing, high-end manufacturing, where the demand is really exceeding supply, but they have very specific needs for the types of facilities that they need and the work environments that they want to go to. And then adding a modest amount of housing on the parcel of land that Peter had mentioned was, across the street and never part of the planned development. And we really see these as, the combination of the two they're complementary. They reinforce the competitiveness of all the different uses. So it makes our office buildings more valuable or more desirable to occupants. It allows the biomanufacturing facilities to be viable, and it creates a more dynamic environment for all of the uses. So if you could advance the next slide, which sums it up, they are interconnected. The residential, we know there is demand for in the marketplace. We've got a great partner that we've teamed up with in Avalon Bay to help execute that. The proceeds that we as the owner of the land expect to get to that will be reinvested into the central square to create that retail amenity base. And the residents of these townhomes will help create a market that will support those retail operations after hours, in the non-business hours when the office and manufacturing buildings may be not occupied. And then that central square creates an environment coupled with the additional density that we can add on the site, the location, the infrastructure, and you folks, the municipality that has started to welcome these types of uses. It allows us to land those commercial users as well. And so those three things combined put us in a position where as the market stands today, we'd be prepared to proceed on a speculative basis with or without a tenant for a biomanufacturing facility. And putting these three things together greatly enhances the probability of actually executing on a development plan that puts to work that development capacity, creates the jobs, creates the tax revenue, and really prepares the campus at Marlborough for the next 20 years to be competitive as a mixed-use facility in areas of our economy that are expanding. So I think that's all I really had to say at this moment. I'll turn it back over to Peter to keep going.
Thanks, Phil. Next slide, please. So turning to the nuts and bolts, the depiction to the left reflects the existing industrial zoning outlined in blue. And to the right, it shows the extension of the Results Way mixed-use overlay over the site. This would be an overlay district in that it's superimposed over the underlying industrial district. So next slide. This is what the Results Way mixed-use overlay district would offer to realize Phil's vision that he's described. It would allow for the restaurants and cafe and those sort of externally focused uses by right rather than by special permit. It would permit up to, but not more than, 100 residential units. And those we've committed to limiting to that undeveloped parcel. Those would be allowed by right, but no more than 100. And the overlay district also provides greater flexibility. The existing industrial district requires what's known as the large tract development, which requires a site of no less than 90 acres under common ownership. And that's led, in this case, to a condominium structure, a commercial condominium structure, being required in order to keep it under common ownership. Next slide. And that would not be required under the overlay. This provides the committee, we thought these two tables would be helpful to summarize why we are seeking to implement this master plan by means of this the expansion of this existing overlay district. This just specifies the uses. So you can see in the second column, the industrial uses are what's allowed today. And you see very clearly that multifamily, no residential multifamily is allowed, and restaurants and cafes are only allowed by special permit. You see in the Results Way mixed-use overlay district in the third column that those uses are allowed. So in general, the uses are less restrictive in the overlay district, which is just across the street. Next slide, please. This table provides the committee a summary of a comparison between the industrial and the overlay district with respect to bulk and dimensional requirements. And I think it's worth noting that they don't vary dramatically here. In fact, in some instances, the overlay is more restrictive. But as I had noted, the one item that's not noted in this table, the large tract development concept, which is a requirement for this site, does require 90 acres in common ownership, no less than. And the Results Way Mixed Use Overlay District does not have that requirement. So it certainly would free up Greatland for both financing and future planning, subject to the existing condominium structure and perhaps any easement agreements, greater flexibility in planning on the site. Next slide, please. So in addition to the map and the potential expansion of the Results Way Mixed Use Overlay District to apply to the site, we're suggesting some minor tweaks to the text of the Results Way Mixed Use Overlay District to do effectively three things. Number one, it currently contemplates one mixed-use project. This would allow for 2 master plans and 2 such mixed-use projects, so that there would be no impact on the existing investment north of Cimarano. There would be no impact on the zoning related to the existing development outside of this site. And that's very important, so that the 2 what are described as sub-districts would operate independently. The second point in terms of the tweaks and the revisions is that you may recall that Revance was a contender for the first biomanufacturing facility here. And I think Phil and his team expect to find other users like Revance. They need some clarification because in this biomanufacturing, in these processes, there's often either handling or manufacture of chemicals that could be deemed hazardous. That is a current prohibition. And so we would ask for the committee and the council to consider allowing for biomanufacturing uses, such as Revance and other biomanufacturing users, to be able to handle and manufacture materials and chemicals that may be hazardous. They're obviously doing this in accordance with all other applicable law. There are different ways to do this. We're certainly open to the council and the committee's input on this issue, but we do see it as important to attracting some high caliber tenants. And then lastly, as we mentioned, the revisions to the Results Way Mixed Use Overlay District would limit and restrict no more than 100 units of housing on the campus site. And these changes are predominantly reflected in what's known as Exhibit A, which is an addition to the overlay. Next slide, please. So I'm not going to go through every page unless councilors have questions, but if we skip to Exhibit A, which is a few more pages, there it is. This is the addition, which is important. So the other changes are not substantive, but they, the ones that we just breezed through, really allow for there to be essentially 2 sub-districts. And this Exhibit A confines really the substantive changes here. And so what you see in the first row, sub-district 1, none of this is changing. This is all what is allowed in the existing Results Way Mixed Use Overlay District. We've just shifted it into a sub-district. Sub-district 2 would be our sub-district. There is a typo, Madam Chair, in that the assessor's map and parcels for sub-district 2, the 3 that are identified, really, it's the third one is in error. The map and parcel numbers that would be subject to the overlay would be map 100, lot 19. That is the undeveloped parcel. And map 111, lot 1-1 and 1-2. That's the principal campus lot. And it's divided into dashes because there are 2 condominiums. So PID number 111-2 is actually off-site. And so that can be stricken, and I assume we can work with the city solicitor to ensure that that's done properly. And that is my error, and apologies for that. But no issue with notice in that we're being over-inclusive here. But the main point to be made is by creating these sub-districts, we're limiting the number of dwellings to no more than 100. And the rights that we have do not impact the other sub-district, the existing Results Way mixed-use overlay. So I'll leave it there. I've tried to be brief, but we may have skipped over items that are of interest to the committee. Next slide. We're certainly open to addressing any and all comments.
Thank you, Mr. Tam. I know we will, as a committee, be going through this overlay district and proposed changes. So thank you for providing a copy of that. I know I had a conversation with you, and I think you have had one, and I've had a couple with the solicitor on the map. And I know we will get into that. But if the committee does not mind, we do have Chief Breen with us. He's the fire chief in Marlborough. I had asked him a couple of questions. He has been busy for the past 2 days doing some training, I believe, and he was kind enough to come on tonight. So I don't want to waste his time. And if there's no objection, I would like to use him to go over a couple of the points that were brought up about the hazardous chemicals and biodiversity. So I know one of the comments that you had made and one of the recommended changes is on page 6 of the document that we were given, with you are adding into the category that actually specifically states not allowed, to add into item 3G, hazardous and toxic chemical manufacturing, the words except in accordance with applicable state and federal regulations. So I know my comment, I believe, to you, Mr. Tam, was I believe they would have to meet those regardless of whether we want them to or not. So I think the question for the committee and eventually for the rest of the council is, do we in fact want to allow hazardous and toxic chemical manufacturing in this new part? And by changing this, we would ultimately then allow it in the other side. We had originally said no. I think the thinking may be a little bit different now, but the chief is here with some comments that he had made to me. He's here to answer questions. The other one, I think, was the point made in the planning board's letter to allow for biodiversity, biosafety 3 by special permit. We have they're not allowed at all for level 4. So I want to open it up for conversation by the committee on those topics, if that's okay, since we have the chief with us.
Madam Chair, if I may just make one clarification.
Yes.
And I appreciate your comments and careful review and the chief's availability as well. With respect to the biosafety level, obviously biosafety level 4 is the most dangerous, essentially, and those are categorically prohibited. We're not proposing to change that. Members of the planning board pointed out that while biosafety level 3 uses are technically allowed in the existing Results Way mixed use overlay district, we were amenable to their comments in terms of a potential change to subject a biosafety level 3 use to a special permit in this instance. And so we welcome that input, and we would be prepared to work with the committee and the city solicitor on such a change, if that is the will of the committee. Similarly, with respect to any handling or manufacture of hazardous materials, there are obviously some very good tenants out there that may encounter and need to deal with hazardous materials. Revance was the obvious example here, and that was the impetus for this potential change. There are different ways to structure this, and we would be similarly open to subjecting those types of uses to a special permit as well, if that was the will of the committee.
Thank you. All right, so I guess the topic of discussion, we can start maybe with just the hazardous and toxic chemical, and it's specifically manufacturing. And I know, I believe Chief Green, well, we have Dow Chemical, which is just down the street on Forest, that is a chemical manufacturer. I believe they are manufacturing hazard and toxic chemicals. We have a paint manufacturing company on Route 20. They're manufacturing something that are considered toxic. And I know within the city of Marlborough, we have facilities that may not be manufacturing the hazardous and toxic chemicals, but are certainly using those. So is it something that the city needs to grow as the demand is changing to allow hazardous and toxic chemical manufacturing within this development, or do we want to stay with the not allowed at all aspect? Comments, questions?
Madam Chair, it's Councillor Doucette.
Councillor Doucette.
Thank you very much, Madam Chair. I think there's another question I wanted to ask the people on the line, as far as, you know, if we look at this development overall, it's pretty unique. And, you know, it's, you've got office space. They're trying to put in basically high-tech biomanufacturing within the space. There's going to be housing nearby. You know, is there other locations known that have similar characteristics within a development? You know, having all of this together, or is this that unique and cutting edge?
Well, across the street.
No, the biomanufacturing. I mean, if they put in the biomanufacturing and stuff like that, there's nothing like that. I mean, you know, the other stuff is, you know, yeah, you got a mix of office and, you know, housing, and, you know, that seems to be going gangbusters, which is fine. But, you know, the manufacturing, are there other facilities, you know, there are other developments in other parts of the countries that have a similar layout? Or are we that unique?
Phil, Madam Chair, through you, it's Peter Tam to respond to Councillor Doucette. I think this is a fairly unique site. It's a very large site, obviously. There are certainly other biomanufacturing facilities that are in proximity to the uses that we're contemplating. But to develop them like this, it's a somewhat unusual situation. And biomanufacturing in Massachusetts, as Phil Dorman has pointed out, it's a growing space, and there's so much demand, and there's not enough of these uses. So as Councillor Doucette points out, this is high tech. This is fairly cutting edge, and the market is that these life science users want to be able to manufacture their products within proximity to where they're where they're discovering them. So that's my layman's view of it. I don't know if that addresses the councillor's question.
That's a fair response, and I appreciate your honesty with that. I do think that there is an opportunity, you know, like back in the day when there was, you know, computers were the size of refrigerators, you know, Forest Street was manufacturing them like cookie cutters, you know, as well as Prime Computer on California Avenue, you know. And I think having the, the biomanufacturing in proximity to the biotech centers in Cambridge and Boston is, it's a juicy, low-hanging fruit if we actually get this done. And I do think there'd be a big benefit for the city, as long as, basically the hazardous and toxic, manufacturing process is handled properly and doesn't blow up. And I mean that not literally, but that is a possibility. I hate to say that the town I grew up in had a toxic waste dump that was right next to the town's water supply. And it took decades to get that thing cleared up. So I don't want to see that come to Marlborough, but I think we're beyond that as far as manufacturing process. So thank you.
And I know that we had heard from Meredith Harris, I believe, when this first started, or she's certainly been out there. They are promoting bioscience within the city of Marlborough pretty heavily through MEDC, and I know we have a new facility going in on Crowley Drive. We do also have the engineer with us from the city, Tom DePercio, and I know he has some issues once assuming we get this overlay district dealt with and we get to the development and the site plan, I'm sure that the biomanufacturing piece is relatively new to everybody. So it's a different beast than what we recognize as typical manufacturing that we have a lot of within the city currently. So I think what I want to really focus on is that hazardous and toxic chemical part of it, and specifically the manufacturing, because currently we don't allow it. And that's really where I want to get in. And I know the chief has some information. He had certainly mentioned to me some new rules and regulations and why they came into place. If anybody wants some specificity from him.
Madam Chair, Councilor Landers.
Councilor Landers.
Yes, now that, we have the chief here, and, it's great that he's here. I guess my question, Madam Chair, through you, would be to the chief. Evidently, they have a few companies in mind, and life science, I think, is the way at least we want to direct. Chief, how do some of these things that might come here compare with DuPont? I mean, you guys still go out there once or twice a year, but it hasn't been a serious situation. Are we talking something greater than DuPont, less, or what? Is the chief on, Madam Chair?
He has his mic. He just took his microphone off. So yes, he is here.
Thank you, Madam Chair. I will address my comments through the chair. If that question from Councilor Landers was specific to me relative to, I don't know what's being proposed in this mixed use plan. I am here at the request of the chair, to answer questions that may come up, but perhaps it might be helpful if I just give you a brief overview of my background with respect to this topic. So what happened is the United States back in 1986 passed what's called the Superfund Amendment and Reauthorization Act, and it required businesses in communities under the EPCRA, or the Emergency Planning and Community Right to Know Act, to specify what they were using in their facilities so that literally in your neighborhood, in your community, you would know what was being manufactured around you. Some of that was the result of some industrial accidents. Specifically, in 1984, there was a terrible accident in Bhopal, India, that involved some methyl isocyanate. It was a toxic gas release that killed thousands of people. That and Chernobyl and some other incidents prompted Congress to act. So we ended up with this SARA Title III. I share that with you because that's really what this focus is about. What's going on, and I think the applicant is offering an appropriate compromise. What's going on here is you're looking at a mixed use, so you have an industrial area that permits this type of chemical manufacturing. Typically, however, the residential units are not permitted in an industrial area. So I think it's a good compromise. We don't know what's going to be manufactured and or what hazardous materials will be used. I will tell all of you, though, that hazardous materials exist everywhere, primarily even in our own homes, which are not reportable. So the fire department receives information from nearly every business annually on what their inventory is relative to hazardous materials. Hazardous materials, as published under the OSHA's Hazard Communication Standard, there is a list of those materials, but they range from simple things like cleaners or degreasers or even quantities of fuel oil, all the way up into what's called extremely hazardous substances. So depending upon the material that's used depends upon, your level of concern, if you will. So I don't know what's going to be proposed in this mixed use, but I think it's appropriate for the council to be concerned relative to, what will be manufactured, stored, and or used. And until you know that, I don't know that, you want to give an applicant carte blanche to just manufacture whatever they want, given the mixed use application that's being requested. That is my opinion. It does not fall under my purview. But I will tell you that I think it's appropriate to know what you're talking about in terms of substances or toxic materials or hazardous chemicals. But that's a general overview of why this is an appropriate subject worthy of discussion.
Madam Chair, if I can just expand upon that. Councilor Landers.
Councilor Landers, you have more questions? Go ahead.
Yeah, I want to expand upon my original question. I guess what I'm looking for, Chief, would we use DuPont as we would say companies coming in could have no greater, all right, hazardous material than what DuPont has had for the last 10 years. In other words, we would set the guidelines of these companies that are coming in. If you manufacture this, fine. If you manufacture this product, great. But when you exceed, some of the chemicals that DuPont has done out there for years, okay, maybe it would require a special permit, and we would look into it and depend upon, your support more and more. I guess that's what I'm looking for, Madam Chair. Because we can't stay away from, hazardous material. I mean, we've talked about it. I guess you couldn't believe some of the trucks that are going down 495, heading up 290 or further south, going on Mass Pike and east and west. So, and if we want to move forward, if we want to get some life science companies in, there's a certain, risk that you take with moving forward. That's all, Madam Chair.
Thank you. And Councilor, I guess to me, it's life sciences to me can be labs and just do investigate and research, and then the labs, if they are successful, could go into the manufacturing stage. So I know even Hologic at the campus, their only research, they have the manufacturing facility off campus, and then they also manufacture everywhere in other facilities.
I'm well aware of that. Yeah.
Chief probably does know what else in the city is a manufacturer of toxic chemicals. I mentioned Dow, and we have the paint company. There must be some on Lock Drive.
Thank you, Madam Chair. I would venture to say there are too many to count. In terms of, I want to be clear about this. Councilor Landers is absolutely correct. There is so much use of hazardous materials as classified by OSHA. It's used daily in nearly every single facility or manufacturing plant. It does not pose an immediate threat. So if I don't want to give anyone or get anyone nervous, it's handled safely by professionals each and every day. It's the quantity and what the amount is what you really need to know. So some of these R&D facilities use very small quantities of hazardous materials, and they go without incident each day. So that's not really the issue. And again, reporting is something that occurs and is mandated. There's tremendous regulations, both federally and state, regarding the use, storage, and disposal even of hazardous materials. So I don't venture to know how much hazardous materials is manufactured or used here in the city of Marlborough, but I can tell you that if somebody were to come to us with a particular address for a business and makes an inquiry as to what was used in that facility, we would look in our files and we would be able to produce records like Tier 1 and Tier 2 reports or MSDS sheets, material safety data sheets, for the chemicals and or products that they use there regularly.
Madam Chair, Councillor Navin. Oh, sorry, Mr. President, please.
You're on the committee. You go for it.
Councillor Navin.
Thank you, Madam Chair. I am sure, Chief, I appreciate you being here tonight and providing a little bit of information here that I think can calm some nerves. I'm assuming that some folks who might be watching this are feeling the same way I am when you see some of these words thrown out here on the paper. You know, when we talk about level 3 biohazards, when obviously level 4, which is not being discussed here, and some of the, I'm assuming what is level 2 and level 1. Any examples that you can throw out that, you know, it's just to have a better idea of kind of what these are? I know that, you know, different chemicals are all over the place, including in our homes, but just so we can kind of get a better sense of what we're talking about.
Madam Chair, through you.
Yes, Chief.
This is Peter Tam.
Sorry, I was looking at my screen.
If you'd like to hear from the chief, I'll. But I'd like to just clarify. I think there are two different issues here, but they are related in that they deal with risks, and we want to make sure that the committee and the council and the public understand what is being proposed and what's not being proposed. With the biomanufacturing uses that are contemplated, such as Revance, that clearly had the support of the community, and for uses like that, no doubt there will be some tenants that Phil and his team find are interested in this site for all that it offers, that their processes do involve components that involve hazardous compounds. And whether, like Revance, that involves what could be considered manufacture of some of those hazardous compounds is an open question. So we don't submit that this is going to be a DuPont operation. We submit that this is going to be R&D, life science, biomanufacturing, and there may be incidental handling and manufacture of chemicals that may be hazardous. And so that's the issue. We need clarity in the zoning because of this restriction. The question about biosafety levels is somewhat separate. And that arose initially at the planning board. And we provided, I believe, the planning board some comfort in their issuing of a recommendation to say that notwithstanding that in the existing Results Way mixed-use overlay district, biosafety level 3 uses are allowed as of right, not 4. We will submit in this sub-district, if the zoning is expanded, that we would subject any biosafety level 3 use to a special permit. And that's something that if the committee and the council are comfortable with, we would be very willing to stipulate to. The biosafety levels are sort of proxies, and what they are is just safeguards that protect workers in the community. And the rankings are 1 through 4 based on the organisms being researched. Number 1 is pretty innocuous. So by means of an example, this is low risk microbes. I'm speaking with only the authority of being the son of 2 marine biologists. So there are probably others, including on your planning board, that know a lot more about this. But biosafety level 2 deals with moderate risk human diseases. So by means of example, EEE or staph infections. Level 3 deal with microbes that could cause more serious health risks. These are like an example would be a bacteria that causes tuberculosis. And level 4 are prohibited, but those are obviously the most dangerous. So I hope that's responsive.
That is responsive. Thank you, Peter. I appreciate that. I would just submit the comment, Madam Chair. You know, certainly it's exciting that Marlborough is being focused on as one of a handful in communities that is, you know, authorized for and promoted as a biomanufacturing community. Not something that I am looking to stem at all. But if we are looking at authorizing housing in this area, I do think that the planning board recommendation does make quite a bit of sense. We don't want to just be letting people have these things by right. And if there is a way that we can still have another bite at the apple, as it were, and have some oversight for something that is coming in via special permit, I think that's something worth considering. Thank you, Madam Chair.
Thank you, and we will definitely get to the planning board's recommendation as we go through this, and I would agree personally that I think that having the level 3 labs by special permit is probably not a bad idea. I will give to our assistant a document that I found that sort of gives a little bit more detail on the different biosafety levels. It does indicate, for instance, at biosafety level 3 that they must use controlled or directional airflow. So there's building design that has to, and they have to have biosafety cabinets. I can send this to her and she can send it out to all of you so you have it. I'm sure we're not finishing up tonight, so you have it as reference. And I apologize, I found it later today as I was looking through all this information. So I guess to get back to the specificity of the other one on the table is the hazardous and toxic chemical manufacturing. So currently it is expressly prohibited. They have put in an amendment that to me isn't really relevant, because I still say they have to meet state and federal regulations. So the question is, do we want to pull this out of prohibited and have it be something that is by special permit, or do we want to leave it prohibited?
Madam Chair, I think
Wagner.
Councilor Wagner, I think any controls we can put in place for special permit would be preferable than, right, this seems, it doesn't really make sense to me because, right, it would always, everything would have to be per federal and state regulations, so specifying it here doesn't make sense. So the more control we can have over the special permit process is important to me. It matters about the company, their OSHA record, what the quantities. I really appreciated what Chief Breen had to say. It's, you know, my incidental amounts versus large amounts are very different. No one ever plans on an accident happen, but they happen, and so then the proximity for housing is a concern to me. And I'm not sure, I have questions about the housing. I don't know if this is the right time. It fits together with the potential hazardous exposure concerns me. So I don't know. I'd like to ask questions about housing. I don't know if this is the time as well, but just wanted to emphasize strongly, the more controls, the more restrictions, what criteria we can put to maximizing safety is definitely preferable for me.
So you would be comfortable putting this into the special permit category?
Yes.
Madam Chair, it's Councilor Doucette.
Councilor Doucette.
Thank you very much. I agree that having it as a special permit is good. My question more is to do with the wording of it. As far as hazardous and toxic chemical manufacturing, you know, that is in accordance with applicable state and federal regulations. That's the easy part. But when we're talking about chemical manufacturing, we're talking about biotech. For terms go, is this something that should be chemical or biochemical and/or biochemical? I mean, what is the proper terms that should be used here aside from just chemical if we're talking about biotech?
I do not know. Does anybody on the panel? Mr. Tam, with your parental...
Madam Chair, I sort of recognize the concern of those counselors that have spoken and expressed, you know, a need for safety and proper proper limitations. So I tend to agree with the point that you, Madam Chair, made. I think we could eliminate and leave in place the restriction on hazardous and toxic chemical manufacturing in the prohibited uses, and not take exception there, but rather in the permitted uses, where biomanufacturing falls is within the advanced manufacturing concept, which includes high-tech manufacturing, but is not limited to those. So that is the use category where biomanufacturing is permitted. And we could add language towards the end of that provision that essentially captures this. And I'm speaking out loud, but it would essentially say biomanufacturing that may involve hazardous chemicals subject to a special permit, whether it be in the allowed uses or in a special permit section. But that the idea being that this is really the exception to the norm, and the norm being no hazardous manufacturing generally, unless it's by special permit in the context of biomanufacturing.
Right, so to make sure everybody's following, if you go to page 4 of the document where it has E, eligible uses, number 1 is by right, and you go to page 5, D, advanced manufacturing, that's where he's listing all of the things that are already in our code that are allowed under advanced manufacturing. So he is saying he would add within that. So we have the solicitor with us. Solicitor Grossfield, is that the place to have something with special permit, or do we need to have special permits in the special permits section?
Madam Chair, I think if conceptually, if the committee is on board with making these special permits, that our office can work with the applicant to either put it there or essentially add it to the special permit section on the following page.
And Madam Chair, I agree with that. It probably logically follows as a special permit provision if that's the will of the committee and the council.
It sounds like it is. So what I'm hearing from you is we will leave 2G alone and not have your addition of the except in accordance with the applicable state and federal regulations. It will remain in the not allowed category for hazardous and toxic chemical manufacturing. Is that correct, Mr. Tam?
I guess for clarification, I'm not sure if I followed. We would leave 3G alone. So categorically, there's a prohibition on hazardous and toxic chemical manufacturing, but we would add a nuance potentially in working with the city solicitor to 2, and maybe add a 2C, which allows specifically for biomanufacturing with a hazardous chemical component. And we can work on the language.
Okay. I think, does that sound okay with the committee members to have that be added in with a special permit specificity?
Madam Chair, Councilor Navin.
Councilor Navin.
Thank you, Madam Chair. Yeah, I think it does. And I know Peter made the point earlier that we have been talking about a difference between hazardous materials and biohazardous manufacturing. But I do think that, to have that umbrella there makes a lot of sense for people as we continue to talk about housing in the area. Giving us the ability to have that as oversight is helpful. Thank you.
Okay, so, and as I said, we're not finishing this tonight, so at our next meeting, maybe we could have specific language developed between the two of you that we could then have to look at.
Councilor,
Right.
Councilor Dumas, you haven't opened it up to other non-committee members yet?
I have not, no. Would you like to, I know Councilor Ossing had something, but I'll call on you and then I'll go back to him.
Thank you.
I'm outranking him.
Through you, Madam Chair, to the fire chief, my concern with Ward 3 is that they've been promised a West End fire station for numerous years now, and especially regarding to response times. The residents are concerned regarding the response times already, and now we're throwing in a hazardous biosafety hazard level 3 component to the mix. It leaves me a little concerned, and Fire Chief, this is no disrespect to you or your position or to the firefighters of the city of Marlborough. There's 10 possible buildings that are being proposed here that all could have biohazard material in them. In any way, shape, or form, are we capable of handling something like this in this area? I would hate to see something go awry, especially now with response times currently. I know the fire station is in the works, but we don't have a date for that. And now we're putting in a huge circular ring with housing. It's gonna double what we already have now with Quest Diagnostics, the traffic. I'm concerned that if this goes through with hazardous, can we handle it from a fire safety perspective? Thank you.
He put you on the spot, Chief.
And I don't mean that disrespectfully. It's and I apologize ahead of time. I have 100% faith in you. It's just a concern.
Thank you, Councilor, and I'll address the comments through the chair as well. So thank you, Madam Chair. No, we're going to continue to respond and, do our jobs. Certainly, our response, our call volume, demands for services has increased, particularly over the period that I've been here, nearly 6 years now. We've seen a steady increase in demands for service. Yes, while we know that area of the community, particularly West Marlborough, lacks a fire facility, as you all know, we're working on that. We're making steady progress. But in terms of responding to the increased with respect to this project or, hundreds and hundreds of housing units that are being proposed and or have already been developed, we're capable of responding. We have tremendous skill sets with respect to our on-duty personnel, but if it's something that is beyond our capability, don't forget we have regional hazmat teams, we have national response assets, and I'm not concerned in a sense of these products are in every community. The ones that scare us typically are we don't know what's in our residential homes and our basements. There's no regulations for, as they say, a man's home is his castle. We don't know what's present in those homes. Those are the ones that scare us the most. But
so there won't be a need for special training or enforcement or anything like that regarding this. And I'm assuming depending on what is actually being proposed, if we do allow a special permit, then we'll have an idea of what it is. I just don't want the communication to be lost regarding the fire safety and what is actually being done and the training that will be needed to respond to that hazard.
Thank you, Council. I think that's a great point, and I think that's what the applicant is trying to address with respect to a special permit. So without letting our imaginations run wild, if they were to suddenly tell us that they were working some research and development, we had a company that wanted to come here and they specialized in chemical X, and we found out that required special equipment and or training and or response assets, then at that time the community could respond with respect to its expectations on giving us the training and the tools and the technology to address those concerns. That's why I think that this is a really good compromise to have the council look at this from a special permit point of view, so that it's just not a, whatever they put in will, they've already been authorized for that.
Thank you.
Hopefully that makes sense.
And I will add to the nice thing about a special permit is the mitigation. So if we did have that chemical X and they needed special training, we could ask for mitigation for that training. Anybody else with questions? I will open it up. Councilor Ossing, you had something you had wanted to say. Did we cover everything?
Thank you, Madam Chair. Councilor Navin covered it just fine. The special permit, I think that covers it. Thank you.
All right, so do we want to go specifically to the letter from the planning board? where they are recommending that the biosafety hazard level 3 lab be by special permit. Is that something that the committee feels we should be doing?
Madam Chair, I agree with the recommendation from that board. I think it is something that we should take into account and do by special permit. There's one other topic when we're done with this I need to bring up, but we'll finish this one first.
Okay. I know the rest of the letter from the planning board, which I probably should take the time to read. At its regularly scheduled meeting on 4/26, the planning board voted to send a favorable recommendation to the city council with the following conditions: that any biosafety hazard level 3 lab shall only be allowed by special permit from the city council, and that adequate oversight is provided by the required city and state departments to ensure the safe installation, operation, and when required, decommissioning of any proposed level 3 biohazard facility, and that any such facilities inspection and certification reports be made available to the city, and that adequate oversight is provided by the required city and state departments to ensure safe manufacture, storage, production, use, and disposal of toxins with an acute toxicity category 1 or carcinogens or neurotoxins, and that any spills or leakage of acute toxicity category 1 substances, including carcinogens and neurotoxins that could result in groundwater contamination or exposure of the public, be immediately reported to the appropriate city and state departments, and that the development agreement and master plan require and Greatland create recreational opportunities and pedestrian amenities throughout the site and adjoining facilities. The vote was 5-1 on the recommendation, with members Finby, Fay, Hodge, LaVenture, and Russ voting in favor, and member Elder opposed. So I think if we're going to add biosafety hazard level 3 labs as a special permit, that everything down to the development of the master plan would be included in the specificity of that special permit. So we can work on those pieces when that time comes. The pedestrian amenities we'll get to later. And I think this probably does take care of the questions that I had. I appreciate the chief coming tonight. I know he is a resource. If anybody wants him for later discussion, we can always have him come back. It takes care of my issues. It deals with the planning board's letter, so we can move on to another issue that you had, Councilor Doucette, and then.
Yep. Thank you very much, Madam Chair. It's something pretty quick. On page 3, it refers at the top of the table showing the approximate acres and calculations of the following, which is land area, development limitations, maximum development, and approximate number of parking spaces. Table does not include parking spaces.
I'm sorry, are you looking at the results way mixed use overlay?
Yes. Yep. This is.
The blue changes?
This was in the packet that we were provided for tonight's meeting. So page 3 of the results.
I don't get a packet, so I'm looking at the revised by 2021 by ordinance number. It's blue and red.
Sure. Yep.
Light underline.
Right.
So
it's black and white.
Page
3, section B, that refer to a table. There's items 1, 2, 3, and 4. The 4th item says approximate number of parking spaces for the crossed out for the entire RWMOD district. But if you look at the table, which is on page 10, like the last page of this, there's no parking spaces in the reference.
So I'm sorry, my page 3, 2B says restrictions on development areas and such other development limitations may be agreed upon.
Madam Chair?
Okay, this is the reference.
Point of information, Madam Chair?
I'm sorry, who is speaking?
Councilor Rossing?
Councilor Rossing.
If I could, to help Councilor Doucette out, that's talking about the master concept plan that has not been submitted. It is not part of the zoning change.
Okay, so it's not part of the zoning change, but it's within the packet. So that's where the confusion goes.
As outlined by the applicant, the zoning change, then there'd be the master plan. The master plan would contain the parking, the table that's referenced in the.
Right, okay, and it was also with the presentation that they provided us tonight on the last page of that. I was just making the note that there's no references to parking spaces within that.
Those will be one of the numerous details we work out in the master plan and the development agreement.
Understandable, just wanted to make sure it was flagged.
Okay, so if that's the concern that you had, I think I will take a few minutes while we still, it's almost 9 o'clock, to go back to discussion of the very beginning of this, which is A2, where it talks about the actual maps, where this property is located. So I think in my discussion, well, first of all, it currently has it's described in Exhibit A, and it has a little number 1. And if you look at number 1, it says that Exhibit A is on file in the city offices. So Exhibit A with this is a document that includes a surveyor's record, starting from a point, going to another point, heading south, going east, going west, and then ends with the actual map number of the city, which doesn't correspond with any of the numbers that are actually on the document that he has provided as a change. And I know he has amended the Subdistrict 2 map. So I think this is a conversation that needs to take place probably between the solicitor and Mr. Tam. I guess my preference, and I will certainly go with what the council wants, the proposed Exhibit A, which is page 10 of the blue lined document, I would prefer to strictly have map information and not have dwelling units and not have floor. To me, that is master plan and development agreement pieces. This should just be where the site is located. And if I guess what I would propose is that we have Exhibit A, which is Subdistrict 1 as it currently exists, and then Exhibit B, which is Subdistrict 2, and delineate that with either using the GIS map or doing that same sort of surveying and the map. The solicitor, I think, had indicated a map would be fine, and you had a map in your packet. But to me, the proposed Exhibit A changes are not something that I think they don't match with, and I know they're talked about throughout the document as we get to page 5, getting into the specificity of the dwellings that are allowed in the retail establishment. So we can get into that more, but I don't know, Mr. Tam, if you're okay with having.
Madam Chair, Councilor Ossing.
Councilor Ossing.
Thank you, Madam Chair. So put a little context for history for some of the councils that weren't here when the Results Mixed-Way Use Overlay District was proposed back in 2011. By then, it was Attorney David Gadbois. If you go look at the existing Exhibit A, you got to find it in the city clerk's office somehow. I'll be very candid. 700 feet, take a left at the rock that looks like a tree, then go 600 feet, take a...
No, it doesn't have any rocks, but yes, you're right.
All right, but the point I'm making, it's 2 pages of go down this street, go to this line. We've since evolved and figured out that using map parcel numbers is a more effective way that everyone can figure out just what parcel we're talking about. Because if I got to go 700 feet, take a left down Cimarano, and 500 feet, take a right across a brook by a tree that doesn't exist. It was the great first attempt, and they put a lot of work into it. But we've learned over the last 10 years that the parcel numbers, everybody can relatively identify with the parcel numbers really quickly. So what's trying to be done here is take that Exhibit A with the left and the rights to what parcels apply to the original Results Way mixed-use overlay district. And then what we're trying to do is mirror the Results Way mixed-use overlay district to parcels on the other side of Cimarano Drive. And that, this Exhibit A, so if you want to scratch some of the words up top, but the parcel locations, I think adequately articulate just which zones of the Results Way mixed-use overlay district apply. Because I had council's comment early on saying, holy smokes, another 435 units. No, that's not, that's, you really got to look at how this is set up, and it was set up pretty unique in that it doesn't touch the existing one, but it articulates it from 2-page dissertation to a 1 row across a table that says what's allowed in the current one, and then the row below what's allowed in the 2 new parcels that the applicant is proposing to revise the Results Way mixed-use overlay district. So I hope that helps, Councilor Roby, or Madam Chair. That really, I thought, simplified it and made it really obvious what we were talking about. But I may have been looking at it too long.
No, Councilor Ossing, you are correct, and I know that was the question. However, when you look at the document that we approved, it becomes recorded at the Registry of Deeds, and it becomes part of a plan. And if you go through the registry and look at the document and you follow along with the language of Exhibit A as it currently exists, you can see exactly what the parcel is, which at that point was a simple parcel. I think it was 111, what was it? 100, whatever it was one single parcel. That single parcel has now been divided by us into multiple parcels. I think the city solicitor has sent me exactly which ones, looking at the GIS. They match except for 2 of them on the list of Exhibit A. But my concern is if we delete the current Exhibit A piece, we mess with what's at the registry and the document that exists there. And I would like to keep that piece intact and have a new Exhibit B, which would be the westerly portion, the new sub-district 2, and would specify that it is 100-19 and 111-1, 1 and 1, 2, if I believe that's what you had specified, Attorney Tam.
Yes, Madam Chair. Thank you. If I may, Madam Chair.
I'm sorry.
I appreciate your comments, and I think we're really focused on form over substance, and we're happy to work with you and the city solicitor so that the exhibit, which would reference, I think I'm in agreement with you that the sub-districts make sense because we want to do no harm to the existing district. And with that as a sort of a maxim, whether it be a column in a revised Exhibit A or a new Exhibit B, as you suggest, I'm perfectly willing to go in either direction there. The main point that we would have in any exhibit is that the multifamily be limited in Subdistrict 2, and that Subdistrict 2 be limited to these tax parcels. Frankly, we don't even need to reference the tax parcels as a matter of law. We could rely on a map change, but I think it's good to belt and suspender it.
Right, and I believe the development agreement is where we would then go to the specificity of the dwelling units. And as was mentioned before, we did actually amend the original development agreement for the first parcel, where we then allowed more housing. So the development agreement is amendable, and I guess this overlay district could be amendable too. And I know it's mentioned throughout here how many pieces of housing and how much retail. which to me, that's where it really should be. So I think that's another piece that you and the solicitor can work on, and we can bring back up the next meeting.
Thank you.
All right, so we will, we have a lot of more meat to get into this to discuss at our next meeting. I don't know if anybody has any specific questions tonight, or if we just want to.
Motion to postpone?
All right, I had mentioned to Mr. Tam that we have a Urban Affairs meeting scheduled for May 25th. It was to discuss the Woohoo project. We were holding to see what happened with site plan on the 18th. If that's agreeable with them to come back, we can put that on the agenda. If it's not, we can set up another Urban Affairs meeting.
No, we would appreciate that, Madam Chair.
All right. I don't think we need an official motion. This is in committee. We are not finished. We're not recommending anything. So I don't think we need to have an official motion to postpone. It just remains in committee until we're done.
Then motion to adjourn?
We had one more item.
We technically have one more item, but we can let these people go if you want. If there are no more questions or comments, we will get into all of this at our next meeting. I know we took a lot of time tonight on going at the overview and talking about hazardous waste, and I appreciate the time that was taken to do that. The rest of the meeting, we can start getting into the red lines and the blue line changes throughout the document.
Madam Chair, on behalf of the team, we appreciate the time taken by the council and the committee.
Okay, thank you. We will let you go. We will let you know what the time is for the meeting on the 25th.
Thank you.
All right, so
Thank you.
thank you. Where is my agenda? I have too many papers. All right, so we did technically have another agenda item, but as I stated last night, we have on here agenda item 20107-995B, an update for the Wayside Residential. We did approve the extension last night. Attorney Falk was not planning on coming tonight. That was really the purpose of this. There is no real update. So with that, if you want to...
Motion to adjourn.
All right, it's been moved and seconded to adjourn. I will take a roll call vote. Councilor Doucette.
Councilor Doucette votes yes.
Councilor Landers.
Councilor Landers votes yes.
Councilor Navin.
Councilor Navin votes yes.
Councilor Wagner.
Council Wagner votes yes.
And Councilor Roby votes yes. So we are adjourned. It is 8:58. Thank you all very much for your time.